So I think we will get started if everybody is ready. Welcome to our 2020 School Law Conference. We appreciate you all joining us for our second School Law Conference session. Today's session is entitled, They Said What? First Amendment Issues in 2020. I know this is a topic on a lot of people's minds. So presenting today, I'll wait for Jackie to move the slide. Presenting today, myself, Nikki Baser, my partners Dana Fattori-Crumley and Jackie Wernz, and our wonderful colleague Caroline Kane will all be talking through all of the latest First Amendment issues with you.
To say we are living in a time when First Amendment issues are prevalent in schools is an understatement. We are currently living through a presidential election like no other in history, seeing challenges to structures based on race across the country, and living through a global pandemic causing an unprecedented economic and emotional toll on our communities.
So right now there's a lot to talk about, certainly in schools, whether it be over Zoom, in person, with parents, at board meetings, between teachers and students. It's a lot to talk about, a lot to disagree on. So now is the perfect time to sort of go over these issues and make sure that everybody's clear on the First Amendment rules that apply in the school setting.
And before Jackie jumps in, I'll just let you all know that we are going to go through, as you can see, the First Amendment basics here. We are going to try to sort of go through this in relatively short order so you get the lay of the land, and then we have a lot of really fun hypotheticals that we're going to ask you to participate in. We have some polling that Jackie will go over when we get there. As always, for those of you who have attended our webinars in the past, if you do have questions, we will try to get to them. We have a lot of material to cover. We will try to get to them. Please use the Q&A function at the bottom of your screen to submit the questions, not the chat function. It makes it a little bit easier for us to navigate through those questions. We will do our best to get to them, but we've got lots of material, so we'll give it a whirl. Jackie, I'll turn it over to you.
Thanks, Nikki. All right, so we do know that obviously students and staff, they do have First Amendment rights in the school environment. So this is not a situation where we have complete control over what is said or other speech that occurs in the speech environment. And that has been the case since 1969 in the decision of Tinker versus Des Moines, in which students were displaying black armbands. They were wearing black armbands on their arms to school to protest the Vietnam War, and they were disciplined. And in that case, we got the very now quoted comment from the court, from the Supreme Court, that it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate.
So but we also know that teacher rights and student rights in the classroom setting are not the same as they are out in the public. They're not as robust as the First Amendment rights that apply to private citizens just out and about in society. So there's lots of Supreme Court cases in this area, but the standards are, I would say, less than clear, murky. And when it comes to issues like political speech, hate speech, religious speech, and off-campus speech, the courts have left teachers and administrators with sort of not a lot of guidance. There's different opinions in different areas. And as situations arise, it's hard to apply what we have to the novelty of the situations that come up, especially in this current election season and political climate and sort of everything that's come to light with the pandemic. And Jackie's got this great quote up here from this case, which I will give it an A for imagery. As an English teacher, we sail into the unsettled waters of free speech rights in public schools, waters rife with rocky shoals and uncertain currents. And that pretty much sums it up. Nikki?
Yeah, so I think, as Dana suggests, we are in some uncharted waters here, to go with the metaphor. We do want to, though, go through some standards and guideposts for you in an effort to try to give you a way to think about some of these issues as they come down the pike. Again, there's no definitive answers to every question that you may have, but we will try to provide you with at least some thoughts on how to navigate your way through these issues.
So let's start off talking about unprotected speech, which, you know, as a teacher and as an authoritarian, these are the things you can just say no to, which let's start off on a high, because sometimes it's fun to just say no. No, you will not do that. So obscenity goes without saying, not protected speech. Child pornography, definitely not protected speech. Fighting words, not protected speech. That's the whole pulling the fire alarm, you know, just causing something that's going to cause a big disruption. So defamation, true threats, all of these things are things that the courts have recognized over and over again. They can be limited in the student context, at least at events that involve children. And if they're vulgar, if they're lewd, indecent, and offensive, advocating illegal drug use, that Bong Hits for Jesus case was sort of Justice John Roberts' sort of first big time case that he decided, and that was an important one. But those are all things that the schools can say no to without running afoul of the First Amendment.
So moving on then to the category of protected speech, which is clearly the speech that we care about the most today in this conversation. We're going to first look at employee speech, and we're going to look at student speech. But before we do, I do want to talk just very briefly about what levels of protected speech there are, what it means for there to be speech that's protected. So if it is not falling into what Dana just described as being unprotected, then it's going to fall under the First Amendment, and you're going to want to go through the analysis that we're talking about today. But I do want you to keep in mind that when you're doing that analysis, that there are certain types of speech that are given preferred status under the First Amendment. So for instance, we'll often hear or say that political speech is, you know, the most protected speech under the First Amendment. So there are different, whereas something that is maybe not as important to as many people might not be given as much protection. So you do want to keep that in mind when you're working through the tests that we're talking about today. But generally, we're just going to lump everything that we're talking about into protected speech that, you know, at the very least, you're going to need to go through this analysis. So with respect to employees, what does that analysis look like? So we have long had a test called the Pickering test that asks, number one, is the employee speaking as a private citizen or as a public employee? If they are speaking as a private citizen, then their speech likely is going to be protected. And then if they're speaking as a public employee, generally speaking, their speech isn't going to be protected. Even for protected speech, we will then ask the question, is what they're talking about a matter of public concern? So even if they're talking as a public employee, we also are going to make sure that they're talking about something of a public concern. If it's a mere gripe or complaint, if they're just being whiny, it might not fall under this standard. And so on the first part of this, as far as private citizen versus public employee, what you're going to think about here is first of all, you're going to think about the forum. Is the speech related to curriculum or a statement of inclusion, or is it something that the teacher or other employee is just making on their own? Because while a teacher is teaching, teachers are acting pursuant to their official duties, and therefore they don't have the First Amendment right to speak on certain issues while they're in class. So in 2006, the Supreme Court actually ruled on a case called Garcetti, where they created a pretty categorical rule that says that if public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. So that is, that's kind of the general rule that we are working with here. Now, that case involved a prosecutor, not a teacher, who was fired for informing his supervisors of unlawful police conduct, and then he was fired. And what the court said there was, they said that he was not acting as a private citizen, he was acting as a public employee. And so in that circumstance, it is not going to be something that falls under the First Amendment. But there is a lot of interpretation that's left open under this standard. And so you are almost certainly going to need to be thinking about specific case law, maybe getting some legal counsel when you're trying to decide if someone's acting as a public employee or a private citizen, because there's not really a test for determining whether something falls within someone's job duties. You just have to look at this from a practical standpoint to determine whether or not this applies. So that's kind of the long and short of the test for the first parts of it, where you're really trying to find out if the speech is even falling under First Amendment in the first place. And this actually just repeats for you what I just said, basically. So you can prevent employees from discussing their personal opinions and from holding objective discussions on issues that are not related to the curriculum. It just cannot be an arbitrary restriction, and it has to be content neutral. So I do think an important thing for you to keep in mind here is that we are certainly not suggesting or trying to discourage teachers from having conversations about important topics in the classroom. We have a lot going on in our country and our world right now. And in fact, I think for those of us who are parents on this panel, we rely on you and count on you to talk about these things in school in some cases, because you're better at it than we are. So the thing is that when you're considering whether or not to include issues of hot topics in the curriculum, whether it's issues of diversity or issues of politics, it's important to teach students how to discuss matters in a productive and civil manner. And also that the presentation needs to be made by the educator in a manner that is neutral. So, you know, that would be in situations where this is being made part of the curriculum. And we do recommend that teachers be directed to work with the administration, with their PLC, their grade level meetings, to determine what topics are going to be covered in the curriculum, plan those lessons together to make sure that you're doing this in a way that presents things in a relatively neutral manner. And that's not, again, not to say that that you can't present certain particularly diversity initiatives in a manner that aligns with your school's, you know, your school's position on things. But you do just want to be careful that that it's presented in a way that meets these requirements.
Yeah, I think, Jackie, I think these are all really great points. And you talked about Garcetti, which obviously doesn't involve a school teacher, but there have been subsequent cases about school teachers. And the point that those cases make is, look, you've got a captive audience, and in some cases you have a very young audience. And so the really what you're balancing as a teacher and as an administration is you want to convey the curriculum that's been decided upon by the school district in conjunction with those conversations you mentioned, the PLC, the grade level. And so the goal really is to ensure that these conversations take place within the greater context of the educational program that you're offering, understanding that public school teachers are there to really convey this information to students, and also understanding, you know, as you all as educators know better than I, about, you know, discussing it in a way that's relevant and appropriate for the age of the children that is in front of the teacher.
Right, and there is just a distinction again between is it, and most of what we're going to be talking about today is it the teacher's sort of individual speech. We're not really getting into the question from a First Amendment perspective of whether or not if you as a institution, as a school, decide you want to include certain topics in your curriculum, even if they might not be coming from a fully neutral perspective, that's going to be a very different question. And the teacher's responsibility in those circumstances is to teach the curriculum that you decide on. It's not to decide for themselves. On the issue of employees speaking on a matter of public concern. So again, thinking back to this test, is the person acting as a private citizen, and are they speaking on a matter of public concern? I mentioned earlier that if it's a mere gripe, that's sort of the standard my mind goes to the most, is if you've got a person who is a school employee, they're out on their own time, and they're really just complaining about things that are just not matters that would be relevant to other people, that kind of speech isn't going to be protected by the First Amendment, and you as an employer are going to have wider latitude to discipline that kind of conduct. But if the speech is on a matter of public concern, if it's on something that a reasonable person in the community or in a similar circumstance would be interested in, then you are going to have to do some additional balancing in order to decide whether or not you can discipline that or employee or limit that employee's speech. And what that balancing looks like is that you are going to balance the employee's right to speak on the matter of public concern against the school district's interest in promoting an efficient workplace and performance by employees of their duties free of disruption. So again, thinking back to, if you want to think about this as one big test, the Pickering test is what we often call it. It is, number one, the question is the employee speaking as a private citizen? If the answer is yes, then the question is, are they speaking on a matter of public concern? If the answer is yes, then you're going to balance the right to that speech against the district's interest. That is the Pickering test.
So this slide kind of highlights the Pickering test again. Before limiting an employee's speech, school districts have to consider whether the speech impedes the performance of the employee's job duties or interferes with the functioning of the district. Jackie kind of went through the district's ability to limit speech in the classroom. So outside the classroom, the district must show a sufficient connection between the conduct and the employee's job duties and the district's operation before the district can limit the employee's speech.
So there's a number of factors that the Seventh Circuit looks at, or the courts in this area look at, when they're thinking about whether or not an employee's speech outside of the classroom, on social media, wherever, at board meetings, for example, whether it runs afoul of that test. So whether it, first of all, as Jackie said, it has to be on an issue of public concern, but assuming it is, does it have a disruptive effect or impact on the operations of the school district? And so these are some of the factors that the Seventh Circuit has looked at. Other courts, of course, have looked at, is this impeding their performance in some way? Is it impeding their harmony among coworkers? One of the things that we often look at in terms of impeding performance, and this has come up a number of times, we're going to talk about some examples of this, but if a teacher posts something that is very racist or homophobic on Twitter, and everybody in the school environment is talking about it, does that impede their ability to be a role model, to perform their job as a teacher? Again, personal loyalty and confidence, and we can switch to the next slide. Number of factors to look at. So if there is a situation, again, the context of the speech, the time, the manner in which the teacher has, or the employee has engaged in the speech, just because something's on a personal social media account doesn't mean that it couldn't, teacher could, or an employee couldn't be subject to discipline because of that speech, depending again on what impact it has on the school environment. So if you have a situation where a teacher or an employee is speaking outside of the school building on social media, in other forum, and you're wondering whether they can be disciplined because of that speech, these are the types of factors you're looking at. Certainly, connect with legal counsel before you engage in discipline, because you want to make sure you're not obviously running afoul of the First Amendment.
let's transition to student speech quickly, and we want to get to our hypos, so I'm going to go and make sure that we have adequate time to cover those and cover your questions. But the standard for students is, students, like we go back to Tinker, they don't shed their constitutional rights at the schoolhouse gate. In order for something to be limited in terms of student speech, you have to show that it's going to cause a substantial disruption to the educational environment. And it's got to be a reasonably founded belief, and the fear of a disturbance is not enough. So I think you have to remember that it can't just be that you think it's going to cause a disruption or a few people are going to be talking about it, but really it's going to be something that's going to impede your ability to provide instruction and realize your mission as a school. And again, just going to the next slide, I think this, if it's on campus, you can limit it if it's going to reasonably be foreseen to cause a material substantial disruption or invasion of the rights of others. Although it really has to be an invasion of the rights of others. It can't just be you've expressed an opinion that is contrary to someone else's opinion and therefore their feelings are hurt. I know it might seem that that's okay, but that's still not okay under the First Amendment. So you have to navigate that. And we've got some good questions coming in that I think will let us tease that out even more. Off-campus speech, this is all our favorite off-campus speech cases where they, make postings of the principal's head exploding or something else just scandalous and probably irritating to people who are just trying to go about their daily business and run a school. But you have to show that it really disrupted and that it really caused, there's a connection, that word nexus again, which the Supreme Court just loves. They don't like to use the word connection, they like nexus, to the school environment. And if you can't show it, you're not going to be able to discipline the student. So those are the basics.
So since Tinker, there has been further guidance from the Supreme Court about limiting student speech. For example, in the Bethel case, the Supreme Court held that a school can limit lewd or vulgar student speech at a school assembly. The Supreme Court has also held that some student speech may appear to have the approval of the district or be considered the school speech, and therefore it can be limited. The comic shown on this slide aligns with the position taken by the Supreme Court in the Hazelwood case. In Hazelwood, the Supreme Court held that students may restrict what is published in a student newspaper if the paper has not been established as a public forum. The students in this case sued their school district for removing articles from the student newspaper. The Supreme Court ruled in favor of the school and said that the students' rights were not violated. The court made clear that the Tinker question of the school tolerating speech is different than the school affirmatively promoting speech. The Supreme Court held that the school can exercise control when reasonably related to legitimate pedagogical concerns.
So yeah, and Hazelwood was, it was a very interesting case about, as Caroline said, about a student newspaper. It really goes beyond the student newspaper area. It really is about when speech that is being conducted by students, for example, has sort of the endorsement or the appearance of an endorsement from the school. It's coming out under, the school logo, that sort of thing. We did want to just take a quick note that some of Hazelwood has been amended to an extent by this Illinois law, the Speech Rights of Student Journalists Act. This statute basically, what it does is it says that high school student journalists have the right to exercise free speech, even in the press that is school sponsored. So essentially, students are responsible for the opinions, for the articles, and so it really curtails the ability. So what Hazelwood essentially said was, look, if a school district has a pedagogical reason for pulling articles out of a newspaper, student newspaper, they can do it. What this law really does is say, no, slow down, school. The default is that students have the right to publish what they want. There are some exceptions, certainly libelous, slanderous, obscenity. If it's an invasion of privacy, there's a number of exceptions under this statute. But the default, again, is that students are able to publish. if you are going to, start pulling something from a student newspaper, definitely give us a call before you do so. You have the burden, the school district has the burden of showing the justification for pulling any student articles, although it also relieves administrators of liability if they're sued because of a situation where a student has expressed something through a student newspaper. So again, student journalists, if you've got something going on with that, give us a call, we can talk you through it.
All right, so with that, let's get to the fun part, which is the hypothetical situations, the scenarios that we're going to talk through. So we want you involved in this process. So we want you to answer our polling questions. You can do so. The easiest way to do it is to actually just pick up your phone, go to the browser on your phone, to Safari or whatever else browsers are on there, and type in pollev.com and /Franzik, or pollev.com, and then you press enter, and when you get to the box that says username, you enter the word Franzik. You can also text the code Franzik, so same code that's over there on the left, to the phone number 22333, and you can answer there too, but I personally think that it looks a lot better when you use the phone. And this information should be on the next slide so that we can jump in and go ahead and get started talking about our scenarios, but I'll also put it in the chat. So our first example that we want you to think through is we have an English teacher who was teaching about race and law enforcement in the classroom, including issues of what defund the police means. And parents complained about the teacher addressing this issue. Upon review, the principal learns that the teacher was presenting this in a neutral fashion, discussing arguments for and against the idea, and also about this movement in the context of history. The teacher also described that her class had been reading about African American literature in recent weeks, and the parent who reported the concern said that they disagreed with the idea of defunding the police and that they didn't want their students to be riled up about that issue. So with that in mind, and I'm going to go over here to the chat as well to put in, but you can see at the top of the slide here, we have the directions for you on how to answer. So the question for you is, true or false, the school can discipline the teacher for the discussion in the classroom. And so again, this is pollev.com /Franzik, or you can text Franzik to 22333, I think. What do you think? So yeah, right now we got about 95% saying yes and about 5% saying no. All right, so 95% saying false, 5% saying true. I tend to agree with those of you who are saying that this would not be a circumstance where you could discipline the teacher. And that's because, as we described, this teacher was actually doing exactly what we said that should be done, which is talking about this in a neutral fashion, putting it in the context of history, not advocating for one side or the other. Now, if this were part of the curriculum, we would really have no question, right? So this is why we suggest that teachers go to their administration or their PLCs to talk about what to include. That way we're able to say very clearly, this is it's a part of our curriculum. And remember too, that if your school district determines that, or your school determines that it's appropriate to have more advocacy in the classroom, as of right now, that is something that we believe that you are able to do. Now, You may have heard about, if you follow me on Twitter, you've seen that I've been tweeting about a recent executive order from the White House, in which the White House called into question whether certain subjects could be addressed in the classroom by grant recipients, specifically issues involving bias training in diversity, equity, and inclusion. Right now, that there is not an interpretation of that by the Department of Education that would lead us to tell any of you to change your practices when it comes to either employee or student training or curriculum. If you'd like more information on that, please contact me. But although it is an extremely important thing that we need to be keeping our eye on, right now, there's not really any specific action that you would need to take. But again, hopefully you're following me on Twitter, and I will keep you updated on that as we learn more.
Just, Jackie, before you leave off this slide, a couple thoughts. First, there was a question in the chat that I just wanted to answer because it was a quick one, which is is this the case for college or K-12? We're talking about K-12 here. I know there was a question, I think, in the Q&A earlier about case law. There is a number of cases in the Seventh Circuit that talk specifically about the difference of sort of the First Amendment rights of teachers in classrooms that are in K-12 classrooms. The issues we are not addressing here are the issues that college and university professors have. Their First Amendment rights within their classroom are very, very different, in large part because of sort of two factors. The first is that they do not have a captive audience, and second of all, because of the age of the students involved. So when we're talking about the answer to this hypothetical and others about what you can do, what teachers can and cannot do in a classroom, we're talking specifically about K-12. And I will make the point which Jackie made earlier, which is, you know, the discussion in high school is also going to, of course, look different than the discussion at the K-8 level. The K-5 is going to look different than 6 through 8. I know Dana is the 8th grade teacher in our midst, but obviously your ability to sort of talk through these topics is going to be impacted. The way you do it is going to be impacted depending on the age of the student. So thanks for that question in the chat.
There's another question that I think sort of fits here that I'm also going to take. I'm reading the question. I heard of an incident in which a teacher was discussing George Floyd with a class and some of the students made comments like he deserved it. Can a teacher correct this statement directly? And, you know, obviously, I think the way you phrase the question is, can a teacher correct this statement? Yes, but I think there's a way to do this that is going to lead us back to discussion, academic discussion, and away from argument. And I think the way the teacher does it is very important. And I think you go back to what Jackie was saying about what is the system for punishment in our country. And, you know, we don't punish people when we're arresting them because there's a presumption of innocence. And you're talking about things like that and teaching it in context. So it's not that you can't talk about this. And currently, you know, George Floyd was probably not a part of anyone's pre-existing curriculum because that is a very in the moment current event that just happened and we're all still experiencing it and going through it. But I think the way you respond to questions like that, especially in the classroom, is an important way to sort of live these principles that we are talking about esoterically and put them in practice, which is to show both sides, have an academic perspective, not like a he said, she said sort of debate that you would see on TV. The things you see on TV are not at all helpful today in these areas.
We can't imagine what debates you're talking about, Dana. So we'll move on to the next typo.
Right. I mean, and I will just say on that question again, I think that's why it's so important that you be thinking through as a school or as a district what curricular direction you want to take with these things, because that may give you a little bit more leeway to share a perspective that kind of aligns with your values and what you're trying to teach students, your social emotional learning. In a way that if it's just a random teacher acting kind of on their own without that direction could be more likely to lead to complaints. All right, let's go to our next hypo. Caroline.
Okay, hypo 2. During a class conversation about the current election, a student asks a teacher about his political affiliation and who he is voting for. The teacher answers the question honestly and guides the student back to a neutral and civil dialogue with peers. True or false? The teacher can be disciplined for answering the student's question about which candidate the teacher backs in the election.
All right, so just as a reminder, this is at pollev.com/frantic on your browser. And I will say that while people are voting, we did get a question, a good question of, can a student or parent request to opt out of a defund police discussion, or if Project 1619 is a reading, can a parent or student opt out of that part of the curriculum? I think that's a great question. I had a really amazing conversation with a large group of administrators at the ICEAL conference maybe last year on this. And you know, I think we've long taken the perspective that if it's your curriculum, it's your curriculum, and that, you know, we don't let, you know, students opt out of having an iPad, just like we don't let them opt out of using a math book. And I think unless there's a valid reason, there would be very, very narrow circumstances where we might find something based on religion or something else to back it up. I don't think that we would allow that opt out. What do you think, Nikki?
No, I would agree with that. I think there are some very specific provisions of the school code that allow parents to opt out of certain curricular items. The one that comes to mind most readily is sex education. But generally, I think, Jackie, you are correct, which is that it is sort of a never-ending road. Then we don't allow students to opt out of math. We're not going to allow them to opt out of the curriculum of the district. The district's curriculum is set by the school board members and by the superintendent. The board members obviously are elected officials. They have a lot of discretion. Case law is clear. They have a lot of discretion to set the curriculum. And obviously parents have a right to direct the education of their students, but that means they can obviously disenroll them from a public school and place them in a school that's more to their choosing. But it doesn't allow them to dictate the terms of the curriculum, other than, as I said, those provisions of the school code that specifically allow it.
Sex and dissection. That's the study.
Sex and dissection. That's great.
In the blanks, sex, dissection of frogs. Out of those two things.
All right, Caroline, it looks like we've got our votes in.
All right, so the answer is likely no under these facts. The teacher should not be sharing his personal political opinion in class. However, one stray opinion or comment probably isn't discipline worthy. And you know, given how volatile the political environment is now, it's better for teachers to pivot from the question and use this as an opportunity to have a conversation about why we have a secret ballot or the voting system that we do. So the teachers can choose whether or not to use this opportunity for informal remediation.
All right, Dana, you're on our next one.
All right, our posters. A teacher has signs in the classroom saying any functioning adult for President 2020 or dogs 2020 because humans suck. Are these permissible? Or I guess the school can tell the teacher to, or tell them, the teacher, to take down these political posters in the classroom. Is this true or false?
I think our firm is entirely team dog. We have very few team cat members.
We have a few.
Cats. We have a few.
Cats are so allergy causing.
All right, so we've got about 95% saying true and 5% saying false.
All right, so the trues have it, although you have to take everything in context. This is the example of everything must be taken in context. If some English teacher is doing a unit on satire and has many satirical posters, works of fiction displayed, and you're studying it, you could definitely have these as part of that array. But just having them up generally, it's going to be impermissible because it's going to be political in nature.
All right, Nikki, take us on our next one.
Okay. All right. So a teacher attends a school board meeting wearing his MAGA hat to talk about police in schools. Can we, maybe we'll go to the, can a teacher be limited from wearing the MAGA gear to a school board meeting to speak in support for President Trump in 2020?
Love it when we do the polls and it gets close. I like it when there's a,
So yeah, I think this question is actually kind of complicated and maybe not. There may be more than one answer, so we'll give it to you all. I think in terms of limited from wearing the MAGA gear, I think the answer is no. A teacher can come to a school board meeting, they can speak, they can wear whatever they want to the school board meeting. Obviously, I think you could limit, the same stuff that Dana was talking about before, obscenities, especially if there's students in the audience, but certainly not, you couldn't prevent them from wearing political gear or garb to a school board meeting. I think the question about whether they can speak about support for President Trump, I know we have another hypothetical coming up. I just would caution about, we can talk about this a little bit in a moment, about talking on issues that are unrelated to the school district. But certainly you could not limit them from wearing the garb. I think we have a second question on this. What if a school board member was wearing the MAGA hat or the MAGA buttons? Can the board limit that? I guess true is that they can limit it, false is that they can't. Is that what we're doing, Jackie? Okay.
Can the board limit that? True is yes, false is no.
Okay, awesome, thank you. All right, we've got a little bit of a mix here. Yeah, I think this is one of those questions that's, I think, a little bit tricky, and I don't know that there's a straightforward answer. I think the first thing I will say about this is that wearing a political statement, a button or a hat as a school board member could run afoul of the State Officials and Employees Ethics Act, which generally and sort of broadly prohibits political activity of school board members and employees while carrying out their official duties. I think it's an interesting question, though, as to whether the First Amendment rights of that board member would trump the Ethics Act. And I don't know that I've ever seen a case on this specifically. So I think it's an open question. I think what we would advise generally, and understanding that, board members will do what board members do in some circumstances, is that to the extent that board members can not bring those types of buttons or hats or political, affiliated statements into board meetings, I think, better for the school district. We are going to have a hypothetically imminently about, whether someone can talk at public participation about certain political matters that are swirling. And I think to the extent that board members can keep that out of the conversation and focus on the business of the school district, you're going to have a lot cleaner, a lot easier board meetings, and an ability to focus really on the school district, which is what the board is supposed to be doing, and carrying out the board's business without the distraction of a political debate in the midst of a board meeting.
Right, we had a good question about, what's the limit for what you can wear? Can you wear a Confederate flag? Can you wear a swastika? And I will say there is a line. There is a line that can be crossed. I think that the Confederate flag and the swastika are across that line, where we would be able to, looking back at the standards that we were discussing before, if it's a student, we would be able to reasonably predict a substantial disruption based on the swastika, the Confederate flag. However, there are some very interesting cases, one from our jurisdiction that involved a student wearing, I believe, a t-shirt that said, "Be happy, not gay." And the student was made to turn the shirt inside out. And this went all the way up to the 7th Circuit, which is the highest federal court in our jurisdiction. And they found in favor of the student. So even though I think there's a very strong argument to be made that that shirt would potentially cause harm to individual students who are homosexual in that environment, the court felt that there needed to be a more evident disruption. So the line is there is a line. I think swastikas and Confederate flags cross it, but you have to be very careful, because where that line ends is maybe not where we would necessarily think it does.
Yeah, although it's interesting, those cases are so contextual time-wise too. I think, some of even the Confederate flag cases, I think, have come out in opposing directions. But I think now, given the sort of volatile, tension in this country over racial issues, over issues related to LGBTQ, I wonder, whether the Seventh Circuit would come out differently today on that case. Certainly, I think, if a board if this happens at a board meeting and a board wants to err on the side of asking someone to remove an article of clothing or a sign that runs afoul of the school district's mission and their inclusivity, their anti-discrimination statements, I'd rather be on the side of supporting the removal of that kind of disruptive and hateful speech. But I think you're right, Jackie. I think these questions are really gray, and that's certainly the case with all of these.
Right, and I think we could talk about it, because there are groups out there that exist, that their sole purpose is to espouse values that maybe might be contrary to what a school believes, or what their foundational sort of culture is, that are very litigious and like to file lawsuits about schools that limit their speech. So I guess the long and short answer is you probably are going to want to think very carefully about requests or steps that you're taking when it comes to this speech that might be on the line or a little less clear.
Right, and I think the other thing that's going to come on a later slide is just how you restrict speech and whether it's viewpoint neutral, Jackie. And I think the case with the Be Happy, Not Gay, I think the way they restricted speech was really one of the fundamental problems with the case. And I think being mindful of that as we move into this election season is very important. So here's another hypo, which I'm sure everyone has seen their share of fair tax commercials if you're watching this from Illinois. To what extent may speakers at school board meetings discuss political issues? For example, the fair tax amendment versus the merits of a specific candidate. So this is not just saying I like Trump or I like Biden, but actually talking about the fair tax amendment in the context of a school board meeting. Can the board limit that, true or false?
Well, this may be the closest one we've had yet.
Oh, so this is an interesting issue. If they connect it to something that you are talking about at your board meeting, so if it's connected to a discussion of your revenue or your funding streams or what your budget is going to be going forward, then that's going to be permissible speech because it's on a matter that the board is discussing. But just generally standing up and talking about support for a political candidate that doesn't have anything to do with the school district, that can be a time, place, or manner restriction, that you're saying that we're talking about things that are related to the school district, our budget, our curriculum, our objectives. We're not going to just have an open forum that's free to talk about political candidates, anything that's out in the public, being discussed in the public domain. That's not what a board meeting is. A board meeting is for the business of the board.
I apologize. The next hypothetical, I just want to be clear that this Bitmoji is of me. My daughter made it. It is clearly much cooler than I am in real life. Okay. So a teacher or a school employee uses a Bitmoji of herself, like this one, wearing a Black Lives Matter t-shirt within her signature line of all of her emails, including her district emails. Can the teacher be required to remove this BLM Bitmoji from her email footer?
We also had a question, Nikki, in the Q&A about teachers wearing Black Lives Matter attire in clothing or banners on Zoom. And so I will just add that I think we could consider all of those in answering this this question.
Yeah, and there was a reference to the Hatch Act in support of their ability to do this, which I honestly am not quite clear on. I'm not certain of where the applicability of the Hatch Act is in that scenario. So I'd love to hear the union's take on that.
Yeah, it doesn't apply, but
I was trying to be nice about it, Dana.
I think it's on a similar subject, so I think you read it without reading the whole thing, and you think, oh, this is. I think that's where they got turned around. It doesn't apply.
Gotcha. Okay, so 80% say true. They can be required to remove it. I think that is correct. You know, it is a really challenging situation. I know that there's a lot of teachers who are expressing support for students in various ways, and there is an argument to be made, I suppose, that the Black Lives Matter is not a political statement. That's a statement in support of students. It may be the case in certain circumstances, and I know in the next hypo, I think or a hypo coming up soon, we're going to talk about, if a district puts out Black Lives Matter signs. So potentially, I suppose, and I'll loop back to this after we go through that hypothetical. The issue I think that we're most concerned about here is that if you allow one teacher to express a point of view on an issue, that you've in essence opened up the ability for any teacher to say, to put anything. So then you have a teacher with a Blue Lives Matter shirt on her Bitmoji, and then where do you draw lines on this? And if you say, well, one alienates students and one doesn't, I think there could be varying opinions, and you get into a really big mess about what is a political statement, what isn't, and we really don't want that kind of situation happening amongst teachers. We don't want teachers with signs behind their Zooms all over the place and having students confused as to whether they're expressing the viewpoint of the district, the individual teacher, and what if a teacher posts something like a Blue Lives Matter and a student in the class, a student of color, feels very alienated by that, and does that impede the teacher's ability to teach? So I think we get into a real murky territory here. I think the takeaway is once you allow one, you've allowed everything. And that's really where that's the road we really don't want to go down.
Nikki, another related question that I think we could tackle right now is, what about teachers on their personal social media accounts wearing Black Lives Matter, or advocating for one political candidate over the other, or criticizing things that President Trump has put out in the media? Is that an issue? Can the district discipline for that? And my take on that would be no. I mean, unless it's something really egregious that just is completely offensive and would interfere with their ability to interact with kids, I don't think you can limit that. It's a personal account.
Yeah, and
this is where I think, oh, go ahead.
No, there's just been a lot of like follow-ups in the chat, and or the Q&A, is this the same true for MAGA gear? Yes. Is the school required to ask the teacher to remove it? No, there's no requirement, but just understand that it could then open up the door to all of these other types of expressions and statements. There was one about a Bible verse with their signature. I think the Bible verse is a real problem because we do have a separation of church and state, and
definitely, that drives me crazy when I see like Bible post-it notes in a special ed file. Like my head explodes. So please, those gently say we don't use our Bible post-it notes on official.
All right. Why don't we
and I do think it's important to keep in mind too that when we're talking about things like a substantial disruption under the student standard or the impact on an employee's ability to do their job, that there is case law out there that helps guide us as to what that means. And it may not always be just that someone's feelings are hurt or that and rightfully so. That may not be enough. So it is really important to remember this isn't something that we respond to with our gut. You're going to want to make sure that you're looking at what the precedent is out there for it. All right, Caroline.
Okay. So in this hypo, a school displays a Black Lives Matter poster in front of the building. True or false? The school can display Black Lives Matter poster outside the school.
We did get a question, I will ask while people are, or I'll try to answer while people are going through, of if it were a student with a BLM Bitmoji putting it in a district sponsored email, would Tinker protect that student? And yes, you would want to be looking there on whether you would be able to, just like if they were wearing it on a t-shirt, you'd need to be able to show that it would be a substantial disruption in order to limit that. All right, so we've got, looks like about 65% saying no, the school can't display, and about 37% saying yes, that the school can display the poster.
So the answer is generally yes. However, the concern is whether or not the school district has opened their forum. So if somebody asks the district, will you post this sign? And you do it, the school district may have opened the forum so that if somebody brings, for instance, like a Blue Lives Matter sign, you would have to do it. Districts do have a lot of control over the mission and curriculum. So if the poster is posted as part of the mission statement or curriculum of the school district, then our analysis would be that they didn't open the forum. So they can post the sign saying one thing and not post the other sign. Yeah. So with our example, it's in the Black Lives Matter Education Week. And during that week, they talk about who's impacting Black lives. They may post a Black Lives Matter poster with that curriculum.
Carol, I don't know if it was just me, but I think Caroline's having some technical difficulty. I'll summarize real quick in case anybody didn't get that. I think the concern here is not so much that the school can or cannot do it. The question is, have they opened their forum now to every sign possible? And so I think the answer would be yes. If someone came to them and said, we'd like you to post this Black Lives Matter sign, then arguably if someone the next day said, we'd like you to post this Blue Lives Matter sign, they've opened their forum, then they would have to post both. But if the school themselves has taken upon themselves to post the Black Lives Matter signs as part of their mission or curriculum, the picture in this case, in fact, is a school district that has the Black Lives Matter Education Week. They participate in that every year, and these signs were part of that. Our analysis is that at that point, they are expressing a support for their curriculum items, their mission, and it would not open the forum, and they are able to go ahead and post those signs and then not be obligated to go ahead and post other signs, if someone came to them and asked them to do so.
So we are at 1 o'clock, but we're going to keep going because there's still a bunch of you on this call, and we do record these so that if for some reason you do need to jump off, you would be able to watch it later. But we got so many questions, we're going to keep going, and so feel free to stay with us. So our next question is involving a training where an employee is in an employee in service, and there are a number of issues being discussed at this. It's a bias training, and the issues include critical race theory, intersectionality, systemic racism, positionality, racial humility, and unconscious bias. And this is in the context of race and sex. And an employee speaks out during the in-service and says that they believe that these terms and the ideas behind the training are racist and sexist against individuals who are within the majority. So who are white, who are male. What do you think? Can this employee be disciplined or be silenced even? It might not even be a question of discipline, but can they be told you can't say things like that during this? True or false? And let's assume here that the institution, by offering this training, has taken the position that it's important for their employees to receive this kind of training in order to serve the population that the school preserves. And while people are answering, I do want to briefly mention again that executive order that I spoke about earlier from the White House, from the president, that has been getting a lot of news. And again, right now, it doesn't prohibit schools from using these types of trainings as a matter of just general questions. So for any of you that are wondering if you need to make changes right now to your training curriculum, no. But with that in mind, we have about 93% of you saying false and about 7% saying true. So we agree with those of you who say that it is false, that the employee cannot be disciplined for expressing disagreement of these ideas, even if the employee's comments go against the culture of the institution. This is different than when you have a teacher in the classroom where they're discussing things with students. You have presented this as a training, and the employees do have the ability, assuming that they're allowed to make comments, they have a right to engage with the material on that issue. If it was a teacher in the classroom, again, if they were saying things like, I hate all this equity training and, you know, white supremacy is a myth, that would be a completely different issue because of the presence of students, because of the potential conflict with the curriculum of the school, and also because just like we don't want teachers talking about their politics, you know, that's something that we would want to control as well. We promised those of you who follow me on Twitter pictures of my adorable children. I was unable to find pictures of individuals sitting in front of Zoom backgrounds, political Zoom backgrounds. So I made my children participate in this by sitting in front of pictures. So my son Isaiah apparently supports Biden, and my daughter Cecily apparently supports Trump. And my question is, they go to school, they go to a public school. Can their public school regulate the presentation of these political signs in the background of their Google Classroom sessions? What do you think? Yes or no? Can these adorable children, I had to include that language, when I'm doing my own bias training, which I do a lot of today, I use myself as an example of someone who is very biased toward her children. Can these adorable children be told to stop using their political candidate Zoom backgrounds? All right, and this one's pretty close. So we got about 60-40 split on this, and it really is an interesting question. We generally think that if you have a neutral rule, like you cannot have Zoom backgrounds, we generally think that is relatively safe to do. And so if you say no Zoom backgrounds, okay, yes, but there is some risk if you don't prohibit Zoom backgrounds generally, and you were to limit this without there being some evidence of an actual or past actual disruption based on political speech in the school environment. And we do know that with certain things like dress codes, there's case law out there that suggests that you might not even be able to make that rule that says no Zoom backgrounds. That could potentially be a First Amendment violation, but we still think that it's a safer bet that schools do take the approach of no Zoom background. We know many of you are already doing that, rather than trying to just pick and choose and limit the ones that you disagree with.
Yeah, and Jackie, I know we have a question in the chat, and I know it came in prior to the webinar as well, about, you know, is this sort of the same with masks, you know, political statements on masks as well if students come into the building? And I think our answer would be the same, right? You know, it's a little unclear if you sort of just said no masks other than spirit wear or plain masks. You might be okay. We'd have to really take a close look at that, though, because Tinker does suggest that there's some allowable level of political expression that students are allowed in a school building, barring that substantial disruption. So.
Yeah, I mean, I think it's so different now. Someone just put in the chat, could we make a rule after somebody puts something up and say it's not allowed? And that's generally a no-no. You want to make the rules sort of before. I think you can if it's something really, if it's
disruptive.
If it's something really disruptive, but to make the rule after, I think just from a logistical point of view and from an optics point of view, somebody puts up a political, you know, what Jackie just showed, and then you say afterwards they can't do it. You know, speaking of someone that's dealt with teenagers when I was a teacher, I'm not sure that's the best way to approach that from a discipline perspective, because telling them no after is not going to be the same as explaining why you have the rule before. If you tell them no after, it's going to turn into more of an issue and just make it more contentious. And I do think this is whether they can wear the MAGA hats and the Biden buttons. And, I think if you would have asked us that 2 elections ago, I would have said, yes, the students can wear them, because how is that causing a disruption? Whether it's Gore or Bush, it wouldn't have caused a disruption. It just wouldn't have. And I think that they have rights, and it wouldn't have been offensive to anyone. And I think we're just in a different place now, and that shows you how you have to take the context of it to make
Yeah, I would agree with that, Dana. The one caveat I would say is that if people have been allowing the Zoom backgrounds or the mask, but it has proven to be now a substantial disruption. I agree with you, Dana. If you sort of were out in the front of this and just sort of said, listen, it's a distraction, no Zoom backgrounds, that's great. But if you didn't do that and all of a sudden you're in a situation where it is causing a substantial disruption, I think that is also a grounds at this point to say, look, there's too many of it. It's causing too much of a distraction. Instead of talking about geometry, we're now talking about different people's Zoom backgrounds, and we really just can't have that. And in keeping with what you're saying, which is that obviously highly politicized, really contentious election happening, where we see even at the national level, the figures that are supposed to be having a civil debate are not, and that trickling into the classroom. So the Tinker test was not only, it was foreseeable that it creates a substantial disruption, but also if it does. So if you are in that position, again, reach out to your counsel to think through the best way to do that, but it is a possibility.
And I will tell you that we are getting so many great questions in the chat. And I will also say some of them have been a little bit more along the lines of, what can we do in our curriculum? Can we send out a message in support of Black Lives Matters? I would highly recommend that you go to our website and register for our next week's school law conference session, which is called Shield and Sword, Law as a Driver of Educational Equity, where we're going to be talking a little bit more about the equity angle and what you can include in your curriculum and things along those lines. All right, but with that, let's keep going through. If I can find my PowerPoint, which I have lost. There it is. All right.
Okay. So in this hypo, a student dresses up as a Native American for Halloween and appears on screen during the classroom costume party. True or false, a student can be required to remove a culturally insensitive Halloween costume.
What do you guys think?
Well, Ross, to answer yet, we're supposed to see.
You gotta let everybody answer. You gotta let the tide of the up and down. It's somewhat soothing. I find the polling to be very
One of the costumes on the list for my daughter was she was going to be Zoom, and she was just going to have a sign on her that said, please wait for the host to let you into the session.
great.
I think we've settled for the non-controversial ghost costume though. So classic Halloween.
Although I find Zoom also to be a non-controversial costume.
Yeah, no, it's true. I thought it was very funny.
Inanimate objects as costume.
Yeah.
You can't go
All
wrong.
right, but so we've got about 83% saying true and 17% saying false.
So the
I think
answer to this question would be very
all right, Caroline's having a lot of
Caroline
problems.
again.
Do you want to just jump in here?
Sure. Okay, so I think, first of all, you have to consider the age of the kids. And this is a hard question to answer because the line between cultural insensitivity and appropriation is a thin one and hard to police. So, if someone is wearing, a costume of Mulan and, they want to be Mulan because they saw the movie, it's going to be hard to say you can't wear that. But I think the way to handle it is to have some neutral guidelines, having, you know, being a part of a computer or being a Zoom screen is perfectly neutral. You could set something along that. So again, setting parameters before, it's kind of like one of those, you know it when you see it, issues. But generally, yes, you can make some parameters on culturally insensitive costumes.
Right. And I think, again, this is just one of those areas where it is extremely, it is a hard thing to figure out. There is a line. It does exist. Blackface is across that line. I think we would have no question to tell you if you called us, sure, prohibit that. Tell that student they have to go home. But if it is being dressed up as, you know, dressed up in a particular culture, there's a lot of gray area there in the law. And so we do want you to be careful and focus more on those guidance, like Dana mentioned, like kids can only dress up as inanimate objects, or we do not allow weapons or gore. You know, those types of things will be easier to police. All right. Our next question is ripped from the headlines, where a girl was trying out for the varsity cheerleading team, did not make varsity, made junior varsity, and on Snapchat went on a F-word tirade saying F cheer over and over, and talking about her cheerleading team. And the question is, she was then removed from the junior varsity team. And so the question is, the cheerleader can be kicked off of the junior varsity team for her F cheer Snapchat posts. True or false? I always love it when the one side comes out, you know, with a bang. True is coming out with a bang in this poll here. So we've got a lot of votes for true. Can this cheerleader be kicked off of the junior varsity team? And so a lot of people who may be jumping to the true side here may be thinking of, well, athletics is a right. I'm sorry, I always get that wrong. Athletics is a privilege, not a right. However, recent case law, including this case, which came from another jurisdiction than ours, has really peeled back our ability to just say we can do whatever we want with kids in extracurricular activities and athletics without worrying about the First Amendment. And the court in this case, because this conduct occurred off campus on the student's own time and didn't cause and couldn't be reasonably foreseen to cause a substantial disruption, the Third Circuit Court of Appeals said that this student could not be removed from junior varsity because of her speech. Now, again, this is one of those areas where the line is there, but it can be very hard to police. And there may be circumstances, I know Nikki mentioned before, sometimes you just take the risk, so there may be cases, for instance, if this had involved bullying or something where someone was, you know, individually, it was the victim, where we would maybe push the line a little bit on it. But with this, at least one court in different jurisdiction has recognized some limitation on our ability with respect to extracurricular activities in sports.
So Jackie, I don't know, we can do this last one quickly. I know there's a few other questions.
Okay.
So this one was essentially, could a student, what happens if a student posts something online that says that the numbers that the school is putting forward related to COVID infections are wrong, that in fact the numbers are much higher? What happens if they start publicizing that? Can they be disciplined for their criticisms of the administration?
Right. What do you guys think? Can the student is going online saying, the administration is lying, that really they're keeping their numbers low so that we can be back to school in person, but it's not safe? What do you think? Can they be disciplined? So we've got a lot of falses and just a little bit of fews. What do you think, or of trues? What do you think, Nikki?
Yeah, I mean, I think that's probably right. Students can express what they want. I think that if obviously if it's gaining some traction and causing a lot of disruption and students aren't coming to school and parents are up in arms and all of this stuff, I mean, I suppose there could be a line again that it crosses. But at this point, Likely, if a student is just expressing their views that the administration is not being forthcoming, they do have a right to do that. Obviously, if they're sending this communication to the superintendent or if they're posting it on social media, I think, we have a right to be critical of our schools, our school officials. Again, if it tips over into that disruption, I think that's where we get a little bit murky.
Right.
So,
Well, like this could be defamation. I mean, if you can show that this is not true, you might be able to limit it that way too. If a student publishes something that's absolutely contrary to facts that you know to be true, it doesn't have to be, it's not First Amendment protected anymore then, and you don't have to even engage in that.
Right. Although, I mean, with this, again, I mean, with everything out there about, we want you to be careful when it comes to things like COVID, because if people are questioning the information that's being shared, there's the difference between that and lying. And with defamation, you would have to show that, that it was untrue, that they intended it to be untrue or mistruth. Do we want to tackle these questions? I know we're over on time, but there are a lot of people still here with us. So,
yeah, I'd like to tackle the issue of just the question about substantial disruption. Is it just is it subjective? Is it objective? It's not subjective. I want to say that it has to be. I mean, obviously, it's subjective to the extent that school officials are making this determination. But I want to say that and I want to quote from some things from some case law so that you really understand. It's not just sort of an undifferentiated fear or apprehension of a disturbance. It's not a mere desire to avoid some discomfort or, unpleasantness that always accompanies something that is maybe an unpopular view. So there are actually factors that you can look to in terms of substantial disruption. So whether there's an actual disruption. So let's talk about an actual disruption. So is it, are there disruptions in the hallway? Are people, are students unable to focus on learning because everybody's talking about it? Are numerous parents, lots and lots of parents calling? Are they taking time away from the superintendent because they are expressing concerns about something? Do you actually need to replace a teacher temporarily while things blow over if it's a teacher speech? Those are the kinds of things that would be substantial disruption. Or that you've had this situation happen and that this is going to cause a substantial disruption because it has occurred before. Things that weigh against substantial disruption, there's merely just like a buzz about it, a few people are talking about it, a few students have expressed concern, maybe one or two, then I think we're really not in the field of substantial disruption. So again, I think what you're looking for is actual concrete disruption where you've got students and school officials sort of embroiled, or this has happened before and it's likely to happen again.
So we actually have at this point, a relatively old resource online about this, but what I can tell you is that if you aren't already signed up to receive our alerts at www.franzic.com, sign up, because I will, when we get off of here, resend as an alert that document, which I think you'll find helpful on those questions. I wanted to tackle the question of a teacher who becomes known for making frequently cultural insensitive statements and whether or not there's recourse for that. So you're going to have to think about all the questions we talked about today. Where is the teacher making these comments? Is the teacher making these comments as a private citizen on their own time? Are they making it in the classroom, or are they making it out on the street? Because that's going to impact it. But let's assume that you have this employee who's making these comments in the building frequently, or within your environment frequently. I do think that you would get to a point where you would be able to take some action. Just keep in mind in Illinois what is remediable and what is not remediable, and use that, as a teaching opportunity. And also keep in mind that when we're talking about culturally insensitive, we're going to need to be crossing that line into something that would be disruptive to either the students or to the person being able to do their job.
Yeah, I mean, not everything is First Amendment related too. I mean,
right.
It's just a snotty comment and it has to have a cultural overtone. You can have standards for decorum in your building, in your organizations, and everyone needs to meet those. And those are, there's no First Amendment protection there. So I think you also need to really think about that.
Right. If it's just those, if it falls into those petty gripes that we were talking about earlier, and you think about that. Dana, do you have thoughts on the question of if we had the teacher who stood up in the in-service and said, you know, I think that this is all phooey and racist, if that alienated that teacher's peers, can the district force the peers to continue to include that teacher in collaborative work? What do you think about that?
We're not forcing anyone to do anything. If that teacher stands up and causes a disruption, again, there's the whole, does she have a First Amendment right? And how did she go about it, right? And if she went about it in a totally inappropriate way that made everyone uncomfortable, then you need to, first of all, discipline the teacher that made the comment. After the teacher's disciplined, they come back into just like you would with students, they come back into the setting, and it is everybody's responsibility then to work with that person. And maybe some amends need to be made, but you're going to have to work with that person. You're not going to, if the offense is not offense that is irremediable, that you can't fire the teacher, you're all going to have to look and learn to get along. And I think teachers can be very sensitive about these things, but they do not have to like their coworkers. But if the assignment is, we are going to put together a great curriculum on, World War II, we're all going to work together and do that. And if we don't like each other, too bad. We're each going to do our part, and it's expected that you work with them. So we also want to be careful of not giving people rights to be, to not participate in things that are, you're paying them. You have to do what we tell you to do. Don't
right. And what we worry about a lot there is we worry about retaliation claims, because remember, if we just said that teacher had a First Amendment right to stand up in the in-service and share their perspective, if then that teacher is excluded from the collaborative work environment, that teacher could raise a First Amendment retaliation claim and they might prevail. So it's very important that we all continue to work together as we work through these things, but that is a good opportunity to use it as a teachable moment for that staff member with those views that, as to why that might be hurtful.
Right. And I think everyone just needs a refresher. I think this is a good area for professional development, and Nikki is actually working hard on putting together some professional development for teachers on these issues, both in their handling of things in the classroom and with each other. So look for that from us as well.
Yeah, and I know we've got some more questions, but I think we're going to probably need to close up here, and we'll try to reach out to those who have asked the questions and respond. I just want to say as a parting statement, and I think this is in line with what Dana was saying, which is that, and I know these are really difficult questions, and I know you guys are having a heck of a time navigating through this. I will say, and I know this is preaching to the choir, is that districts are in the unique position of being able to refocus and really teach our children how to have a civil conversation about really sort of uncivil times, right? And ultimately, if that's sort of your guiding star or your guidepost to both within your staff meetings and also within your classrooms, I think you're going to be okay. You're always going to have parents who are upset about X, Y, or Z. But if your teachers and your administrators are on the same team and are working together to create environments in which students feel respected and heard, ultimately you're gonna get through this really difficult time, and we're gonna emerge out the other end of it, hopefully soon.
Right. And that's a great note to end on. And everyone, for those of you who are attorneys, the good news is that we'll submit this for an hour and a half of CLE. We appreciate so many of you staying on with us for the whole time. Please do join us next week for our equity session. And until then, take care. Thanks, everyone. Bye-bye.
Bye, everyone.